Premium processing alert. Stop using the $2,805 fee for Form I-907. The envelope arrived on a Tuesday. Inside was a check for $2,805, made out to U.S. Citizenship and Immigration Services, signed, dated, ready to send. The attorney looked at it, paused, and said 4 words her client did not expect. "Don't send this yet." That moment, that pause, saved this family from a mistake that thousands of immigrants make every single year. A mistake that costs them nearly $3,000 and, in some cases, costs them something far more valuable than money. It costs them time. It costs them status. It costs them the very outcome they paid to accelerate. There is a trap built into the premium processing system that USCIS does not advertise. A quiet mechanism that can legally take your $2,805s, restart the clock on your case, issue a notice, and leave you in a worse position than if you had never filed Form I-907 at all. Most people don't know this trap exists until they're already inside it. Today, you're going to learn exactly how it works and exactly what to do instead. For months now, there had been signals, not from official USCIS press releases, not from congressional testimony, just signals that something about the premium processing system was shifting. Immigration attorneys in high-volume practice areas started comparing notes. Filings that should have been straightforward were coming back with complications. Cases that qualified for premium processing on paper were running into procedural walls that nobody had clearly warned about. USCIS has always been deliberate in how it communicates policy changes. It moves through the Federal Register, through policy manuals, through quiet updates buried in processing timetables. It does not send alerts. It does not call you. It posts, and it expects you to read. But the average immigrant filing a petition does not have time to monitor every USCIS policy update. They are working, they are waiting, they are hoping, and when someone tells them there is an option to pay a fee and move their case to the front of the line, many of them say yes without fully understanding what they are agreeing to. That gap between what premium processing promises and what it actually delivers is where the trap lives. The attorneys who started comparing notes were seeing a pattern, a rhythm, almost a script. Cases would enter premium processing. USCIS would use the 15-business-day window not to approve, but to issue a request for evidence. And the moment that RFE dropped, the premium processing clock stopped. When USCIS issues an RFE, issues a notice of intent to deny, or requests additional biometrics, the 15-business-day guarantee resets. The fee is not refunded. The case is paused, and the petitioner is left holding the most expensive receipt they've ever received, with nothing to show for it yet. This isn't a glitch. It's policy, and it's been policy for a long time. The problem is that nobody explains it clearly at the moment when you're being asked to make the decision. Early in the filing process for many employment-based cases, attorneys detected what they began describing as a pattern of premium processing misuse, including a type of I-907 filing strategy not commonly seen in low-stakes petitions. Petitioners filing I-907 alongside H-1B petitions, O-1 petitions, and I-140 immigrant petitions were activating premium processing without first evaluating whether their underlying case was actually ready for scrutiny at that speed. Premium processing does not just move your case faster. It also accelerates the moment when USCIS looks at your file with full attention and begins asking questions. If your petition has a weakness, a gap in the employer documentation, an inconsistency in the labor condition application, a beneficiary's prior status issue, premium processing does not hide that weakness. It surfaces it faster, under a microscope, with a deadline attached. There are really only 3 situations where premium processing makes sense without serious risk. The first is when the petition is airtight, fully documented, no gaps, no ambiguities, no prior status complications. When an attorney has reviewed every page and is confident there is nothing that would invite scrutiny. The second is when there is a genuine, documented urgency, a start date that cannot be moved, a status expiration that creates immediate harm, a business need that can be articulated clearly and verified with supporting evidence. The third is when the alternative wait time creates a hardship that exceeds the risk of accelerated scrutiny. And even in that case, the calculus only works when the petition is clean. Observers in the immigration legal community weren't certain which of these scenarios most petitioners were relying on when they filed I-907. What they were certain about was this: many petitioners were filing without an attorney's honest risk assessment. They were filing because they were scared of the wait, because they wanted certainty, because $2,805 felt like a reasonable price for peace of mind. But peace of mind is not what premium processing sells. Speed is what it sells. And speed, when your case has problems, is not your friend. The warning that started circulating through immigration forums, legal listservs, and practitioner networks was not symbolic. It was not hypothetical. It was built on documented case outcomes. Case after case where I-907 was filed. Case after case where USCIS issued an RFE within the 15-business-day window. Case after case where the petitioner paid $2,805, received an RFE, spent additional weeks or months gathering evidence to respond, and ultimately received a decision no faster than if they had never used premium processing at all. The fee is non-refundable in these situations. That is not in dispute. USCIS policy is explicit. When premium processing is interrupted by an RFE or NOID, the fee is retained. The service obligation, the 15 business days, restarts only after the response is received and deemed complete. What this means practically is that you can pay $2,805 in February, receive an RFE in March, spend April gathering documents, submit your response in May, and receive your decision in June. That is 4 months from the date you paid for a service designed to deliver results in 15 business days. The response from practitioners who understood this system was among the most direct seen in immigration legal guidance in recent years. Stop filing I-907 as a reflexive decision. Start treating it as a strategic one. And the strategy begins before you ever fill out the form. Today, the immigration legal community has confirmed that informed petitioners are taking a different approach to premium processing. They are targeting the filing decision itself. Specifically, they are evaluating whether their underlying petition has been reviewed for RFE risk before any premium processing fee is paid. This is not a complicated process, but it requires honesty. It requires sitting with an attorney, or if you are self-filing, sitting with the USCIS policy manual and asking a specific set of questions about your petition before you decide to accelerate it. The first question is about documentation completeness. Is every required piece of evidence included? Not probably included, not assumed to be included, verified, checked, and physically present in the packet. The second question is about status consistency. Does the beneficiary's immigration history show any period of unauthorized presence, any prior denial, any status transition that could invite a closer look? These are not disqualifying on their own, but they are factors that increase RFE probability under premium processing timelines. The third question is about the employer's record. Has this employer petitioned before? Has this employer received RFEs, denials, or audits in the past? USCIS maintains records, and repeat petitions from employers with prior complications are more likely to receive enhanced scrutiny. This wasn't symbolism. It was a framework, and that framework is what separates the petitioners who use premium processing successfully from the petitioners who spend $2,805 and wait anyway. There is another dimension to this issue that receives almost no attention in mainstream immigration discussion. It involves the interaction between premium processing and concurrent filings. When a petitioner files an I-140 immigrant petition and uses premium processing, they are signaling to USCIS that they want a fast decision. What they sometimes do not realize is that a fast denial, if the I-140 is denied, can have downstream consequences that a slower denial would not. A denial under premium processing arrives quickly. If the petitioner is also in H-1B status or in a status that depends on the I-140's approval for an extension, a rapid denial can compress the response window to a point where maintaining lawful status becomes extremely difficult. A slower denial, while still a denial, at least provides more time to regroup, to consult, to plan, to file a motion to reopen or reconsider with more deliberation and less panic. Premium processing does not just accelerate good outcomes, it accelerates all outcomes, including the bad ones. And when the outcome is bad, speed works against you. This is the version of the premium processing conversation that most petitioners never have. They ask about success. They don't ask about failure. They plan for the approval. They don't plan for the RFE, the NOID, the denial. And when those things arrive faster than expected, the compressed timeline creates pressure that leads to poor decisions. The most experienced immigration attorneys are consistent on this point. Before you file I-907, ask yourself what happens if this goes wrong, and ask yourself whether you want that to happen in 15 business days or 4 months. There is a specific scenario worth walking through in detail because it appears repeatedly in practitioner case studies, and it illustrates exactly how the trap closes. A software engineer on H-1B status is approaching the end of their 6-year cap. Their employer has filed an I-140 on their behalf. The priority date is not current. They need the I-140 approved so they can use it to extend their H-1B status beyond the 6-year limit under AC-21 provisions. The employer's attorney recommends premium processing to get the I-140 approved quickly. The engineer agrees. The $2,805 fee is paid. USCIS, reviewing the petition under the accelerated timeline, issues an RFE requesting additional evidence about the position's specialty occupation requirements. The clock stops. The engineer's H-1B expiration date does not stop. The response to the RFE takes 8 weeks to prepare. It is submitted. USCIS now has another 15 business days from receipt to respond. Meanwhile, the engineer's H-1B has expired. They are working based on an automatic extension tied to a timely filed extension petition, which was filed assuming the I-140 would be approved before this moment. The situation is salvageable, but it is stressful. It is expensive. It requires additional legal fees, additional filings, and a period of uncertainty that the $2,805 was supposed to prevent. This is the trap, not a theoretical one, a documented one, a real one that happens to real people in real families every year. Knowing when not to use premium processing is just as important as knowing how to use it. And the decision tree is not complicated once you understand the underlying logic. File I-907 when your petition is complete, clean, and reviewed by someone with the expertise to identify RFE risk before USCIS does. Do not file I-907 when you are in a rush, and the rush is the only reason you are filing it. Urgency without preparation is not a strategy. It is panic with a filing fee. Do not file I-907 when there are known complications in the beneficiary's history that have not been fully addressed in the petition's supporting documentation. Do not file I-907 when the denial of the underlying petition would trigger serious status consequences that require time to manage. And do not file I-907 because someone told you it always works. It does not always work. It works when the conditions are right. Your job is to make sure the conditions are right before you write that check. There is one more piece of this that deserves direct attention: the fee itself. As of the most recent USCIS fee schedule update, the I-907 premium processing fee for most petition types is $2,805. For some petition types, including certain I-129 categories, a lower fee of $1,685 applies. But for the most commonly used categories, including I-140 immigrant petitions, $2,805 is the number. USCIS has stated that these fees are non-refundable unless USCIS fails to act within the premium processing timeframe and the failure was not caused by an RFE, NOID, or other action that pauses the clock. That last clause is the key. USCIS almost never fails to act within 15 business days on a purely administrative basis. What USCIS does, frequently, is use the 15 business day window to issue an RFE, which pauses the obligation and retains the fee. If you are expecting a refund because USCIS didn't finish in time, understand that an RFE counts as an action. The clock stops. The fee stays. This is not fraud. This is policy. But it is policy that benefits from being understood before you are subject to it. As this issue continues to move through the immigration practitioner community, more documentation will emerge about how frequently premium processing results in RFEs versus straightforward approvals. Advocacy organizations are beginning to compile that data. It will matter. But what matters right now is what you do before your next filing decision. Knowing this right does not make you a criminal. It makes you smart. It means you are prepared. It means you are protecting your family from a $3,000 mistake that comes wrapped in the language of urgency and acceleration. Share this video with anyone in your family who is waiting on a petition. Share it with your friends who are navigating H-1B renewals, I-140 filings, or any petition type where premium processing feels like the obvious choice. It might save them thousands of dollars. It might save their status. Subscribe to Visa Status Radar for more protection. We protect you with real information as the next phase of immigration policy unfolds.